You might have some nice words for us right now, but I saw the pictures. I saw what you did to that child. What is wrong with you? How can you do that?
A Detroit man will spend the next several decades in prison after he beat his young stepson to death. Jamarr Hill entered a guilty plea confessing to murdering the 8-year-old, but at sentencing, the judge blasted Hill for what he saw as, quote, fake remorse. This comes as many have cried foul over the sentence Hill ended up getting. We will discuss it all with criminal defense attorney and former prosecutor Josh Corman. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. According to Wayne County, Michigan prosecutors, 8-year-old Adren Thimes Jr. stood little chance of surviving past childhood, and that's thanks to the treatment that he received at the hands of his own mother and her partner. The boy's grandmother said the malnourished and mistreated child weighed just 33 pounds when he died in November of 2024. Just imagine that. A growing 8-year-old child weighing just 33 pounds. We go back to November 8th at around 12:30 in the morning. Medics responded to a home on Claremont Avenue in Detroit to try to save Adren, whose wounds would end up becoming fatal. He was pronounced dead at a local hospital, with the medical examiner determining his cause of death to be multiple blunt force trauma injuries to the head. Now, Adren's mother, 32-year-old Kentoria Moss, and his stepfather, 37-year-old Jamarr Hill, were charged with killing him. This was on November 12th. Hill was denied release altogether, but Moss was actually granted a bond in January, although the exact amount that she posted to guarantee her return to court is kind of unclear at this point. But what we do know is that prosecutor Kim Worthy had this to say about what happened inside that home in November. The alleged facts in this case are chilling. The defendants in this case worked in tandem to beat and eventually kill this poor child, 2 adults against an 8-year-old. Little Adren had 0 chance of surviving. Now, to talk about this horrific story, to talk about Hill's plea deal, which you may say is quite controversial, Moss's continuing case, I want to bring in criminal defense attorney and former prosecutor Josh Corman. Josh, thanks so much for coming on Sidebar. Appreciate it.
Thanks for having me.
You've seen a lot of cases from both the prosecution, the defense side. How hard is it when you have to handle a case that involves the death of a child, and not only a child, a young child, and the circumstances that we're talking about here, beaten to death, malnourished? How tough is it to handle a case like this?
I mean, you're exactly right. I think for both sides, for the prosecution and the defense and the judge and the juries, these are certainly the worst cases that you have to deal with. Looking at the pictures, kind of understanding the circumstances that led to that, they're horrible cases, and they're the kind of cases that stay with you for a long time.
Are they easier, though, to prosecute? Does it affect things if you have 2 caregivers who are arrested? I always wonder that in cases involving the death of a young child, right? It's different than dealing with the death of an adult. There can be complicating factors. There could be alternative suspects. There could be a self-defense argument. When you're dealing with a defenseless child, though, to me, I wonder, is it easier to prosecute and secure conviction?
Well, I think you're certainly you're going to have cases where you have the most sympathetic victim when you're prosecuting these kind of cases. Sometimes, though, these cases can be difficult because there's so much of an unknown. There's not other witnesses to it. A lot of times the medical examiner's testimony becomes so important. In this case, I think it looks like the evidence was overwhelming based on the injuries that the child had, but oftentimes the amount of injuries or the photographs or specifically what exactly was going on or how long those injuries had been there are difficult things to prove in court. And that is a lot of times why you see prosecutors coming up with what some people may think would be a too lenient of a plea agreement. In this case, it sounds like the pictures were horrendous. I know in the sentencing hearing, the judge made a point of saying to them, even after the agreement was reached, that in his career, these were the worst pictures that he had ever seen, and that he thought that a life sentence was certainly an appropriate sentence, but for the agreement that had been reached, and he was going to honor that agreement.
And we'll talk about what that sentence is, but let's just first talk about what he was charged with. So Hill was charged with felony murder and first-degree child abuse. Those are very specific charges, Josh, that don't necessarily require an intent to kill, right? I mean, this is a very specific theory to convict him on when we talk about felony murder and child abuse in the first degree, right?
Correct. So the underlying felony, or the predicate felony in this case, was child abuse. Obviously, in a felony murder case, what that is saying is not that there was premeditation or there was an intent to kill, but that someone died during the course of the predicate felony. And it could be child abuse, or it could be a aggravated burglary, a carjacking, arson. There's all kinds of predicate felonies, depending on what state you're in, that if someone dies during the course of that felony, and you can prove that that felony was intentionally committed, then you can be charged and convicted of felony murder, even if it was not your intent for the person to die. So that is what he was originally charged with in the case.
This story almost feels like a PSA, right? It is so important to shed a light on this, and I want to thank our sponsor, Upside, for their support in helping us produce this episode for you. So Upside is great. It is a free app that gets you cash back when you buy daily essentials. Pump my gas, I can use Upside. Go out to lunch, I can use Upside. Maybe I get something at a convenience store, I can use Upside. And why not get cash back when I do all these things, right? This is real cash back. It's money that appears in your Upside app that you transfer right into your bank account. So once you have the free Upside app, you claim an offer for whatever you're buying on Upside. You pay as usual using a debit or credit card. You follow the steps on the app, you get paid. So to find out how much you can earn, click the link in the description to download Upside or scan the QR code on screen. But make sure to use our promo code SIDEBAR because you'll get an extra 25 cents back on every gallon on your first tank of gas. And by the way, a person, they say, is guilty of child abuse in the first degree if the person knowingly or intentionally causes serious physical harm or serious mental harm to a child. And as you said, felony murder is when the child died during the commission of that child abuse. Some people would say felony murder is controversial, right? If someone dies during the course of a robbery or burglary, is it fair to have them on the hook for, felony murder? You might be able to make that argument, not when you're dealing with child abuse. If you are intentionally harming the child and they die, you might not have intended for the child to die, but yeah, you should be on the hook for it, right? I mean, felony murder has gotten its share of criticism or controversy in the past, particularly for defense attorneys, but here makes sense.
I think you're right. I think one of the criticisms of felony murder is, especially when you have co-defendants or you have someone who is involved in a crime, but let's just say there was a robbery going on, but the defendant that we're particularly talking about did not know that anyone had a gun, or there was no plan that anyone was going to be injured. It was supposed to just be a simple robbery, but things went wrong and someone ended up dying. Well, sometimes that can be a tough pill to swallow, that you're now guilty of first-degree murder, of felony murder, and looking at life in prison when that had never been contemplated by the parties involved. But because of the law of criminal responsibility, you're now, you're in for a penny, you're in for a pound, and so you're going down with everybody else. And so for those reasons, I think there is a lot of criticisms on felony murder cases. But you're right, in a case like this where you're talking about child abuse, especially the facts of this case, it's as severe and probably as horrible of a beating as I've ever seen in reviewing cases.
Here's the thing. Before this case could even go to trial, before a jury could even hear it, maybe even a judge could even hear it, this guy, Hill, and his attorney, they reached a deal with the prosecutor's office. So Hill would plead guilty to second-degree murder, right, a lesser charge, and the felony murder and the child abuse charges, they would be dropped. And the guilty plea was officially entered into the record on July 21st, and Hill was sentenced on August 7th with the agreed-upon punishment being 18 to 40 years in prison. Now, Josh, first of all, that means at a minimum he has to serve 18 years before parole is even a consideration, right? I want to make sure I'm understanding that, and if I am, is that justice? Is that fair?
Well, I guess everything's in the eye of the beholder. I don't know exactly how the statutes are, or how the sentencings are calculated in Michigan, but in the jurisdictions I've practiced in, yes, that means that you'd have to serve that minimum period of time before you'd be eligible for parole, and the parole board would ultimately be determining when that person could be released, which I think is why that gives this 18 to 40. And the jurisdictions I've practiced in, there is a set number, so it's not it doesn't leave it up to the parole board to make decisions on an 18 to 40, for instance. Like, as an example, someone would be sentenced just to 30 years, And once they have reached a certain percentage of their sentence, then they may be eligible to meet the parole board. But I guess in Michigan, they give this range of 18 to 40 and leaves it to the parole board to decide if that person has been sufficiently rehabilitated or they believe that he has, I guess, reached the level that he can return to society. So I think Michigan's a little bit different than a lot of other states as far as how they calculate and how they do sentencing. Now, whether this is justice or not, obviously that kind of, again, goes back to which side that you're on. Certainly the defense attorney, it seems, did a very good job in this case in the negotiations. I don't know what all of the ins and outs and how those negotiations took place, but just for us, looking at it from afar, it looks like he certainly reached a good plea agreement for his client.
Why would prosecutors agree to this? Is that to spare the expense, time, and heartache of a trial?
I think sometimes that's certainly it. I don't know if there were some of those mitigating factors that sometimes we don't know about, depending on what, Mr. Hill's background had been, or if, there was any kind of mental health issues or basically what was in his background that would cause the prosecutor maybe to feel like he deserves some kind of a break. Or depending on what the rest of the evidence was. Sometimes there are issues that come up, legal issues, whether the police did something wrong, whether evidence may get thrown out for some reason, and then sometimes plea agreements get reached so that both sides can kind of, take those things into consideration and try to reach an agreement so that those don't become issues in the court as far as what evidence would be presented in a trial. So it's hard to know what the negotiations were since we weren't part of it at all, but I would imagine that there had to have been some things like that discussed.
Now, on the outside, we can criticize it, right? On the outside, we can question it. We could say this is injustice. I don't know the ins and outs of all the evidence, like you said, but I have to tell you, there is an aspect of it that is just so egregious. So not only are you dealing with the death of this young boy, right? And his life taken away from him, taken away from his family. You have the person who causes death. But during the sentencing hearing, Adren's grandmother and aunt spoke. And they reportedly talked about how both Hill and Moss wanted to keep up their image, driving new cars, wearing expensive clothes, but that Adren and his siblings wore dirty clothes and shoes that didn't fit right. In fact, Adren's aunt told the court they ate well, but the kids didn't. They dressed well. They rode in the best car. I think they had the best of everything, but the kids didn't. His grandmother said, "It was premeditated, Your Honor. He is a monster. Whatever time you give him, it's not enough." Now, Josh, I go back to this point, 18 to 40, is this justice? But also from a larger perspective, how many times do you see that, right? How many times do you see a case where a child is abused, but the parents are living well? It's not like a money issue where they're all starving and they can't, earn enough money or have enough money to feed everybody. That doesn't seem to be what's going on here. It's not a money issue per se. Or you have another issue where one child is abused, but the rest of the children in the house are okay. They're fine. That dichotomy, that discrepancy is always alarming to me. And again, why I say this makes it so egregious.
I think you're right. I think those are things in child abuse cases that kind of always baffle us. And, sometimes the only thing that I can come to wrap my head around is the fact that those people don't think the same way that we think, right? And if in fact those are correct, it makes me wonder if this person had some kind of, maybe like lower functioning or had some kind of mental health disorders himself. Clearly, they would not think the way we would think and shouldn't have been parents, right? Which, again, not to ever blame anyone else who was not there to be the guardians, but when other family members see things or people see things at school, there's a reason that the law makes people mandatory reporters. And, I think everyone hopes that people will speak up and say things when they are alarmed. When you see an 8-year-old kid that weighs 30-some pounds, or this kid has to go to school and he's not, he's malnourished or he's not fed or he's wearing dirty clothes, but his parents don't seem to be taking care of him or his siblings, you hope that people will reach out to children's services or to the police or whoever before these things reach a level like they did in this case.
Talking about his statement or what he was thinking or what he was doing. So Adren's death, as you can imagine, was particularly devastating for the Thimes family because this was not the first time his grandmother had to make an identification at the morgue. No, according to Fox 2 in Detroit, when Adren Jr. was just 1 year old, his namesake, Adren Thimes Sr., was killed. incredibly heartbreaking for this family. Now, Hill himself also spoke in court, and he said that he considered this little boy, Adren, to be his own son. He seemed to blame the dirty clothes on the kids just playing outside, the bruises, that it wasn't from abuse, but that it was from boxing lessons. Josh, that's problematic, to say the least. I mean, you can, as a criminal defense attorney, what is your advice to clients who choose to speak at sentencing? He pled guilty to what he did, and now trying to explain other reasons for these injuries? I'm not quite getting that.
No, and I think that's one of the things that probably the least your client can speak. It's usually the better for the defense attorney, and we try to, I guess, counsel our clients to keep things very minimal, keep them simple, and certainly not ever try to minimize anything that you've done, especially in a situation like this where it looks like his attorney was able to reach a very favorable plea agreement for him, and you don't want to mess that up. And then the judge says, you know what, you're not accepting responsibility. I'm rejecting this, or I can't take this plea, which is, the worst outcome that you could ask for. So I'm not exactly sure what all he said in his sentencing, but you're correct. I know the part that I at least have seen where the judge talks about at the sentencing hearing. He says,
well, I'll tell you what. Let's talk about it. So Judge John Gillis, he wasn't swayed by what Hill had to say. In fact, he said, and you mentioned it before, that this is one of the worst cases he has ever had to deal with from the bench.
Well, Mr. Hill, something I learned at a real young age is actions speak a lot louder than words. You might have some nice words for us right now, but I saw the pictures. I saw what you did to that child. And I won't say child, what you did to Adrian, an 8-year-old boy. I don't know how you could do that to someone that you claim you love. I see pictures all the time from homicide cases, people with holes in their head and their chest, sitting in puddles of blood, watch videos of people being stabbed. But these pictures were the worst I've ever seen. That is an 8-year-old child. Just to give everyone a little idea, and I noticed you talked about the boxing, but you didn't give any explanation to all those belt loop marks all over his lower body. Maybe even 100 of them. I mean, that's how many. His entire lower body was covered in belt loops where you had beaten him, and as Ms. Thims stated, even in the growing area. What is wrong with you? How can you do that? So I agree with Ms. Thims. I wish I could sentence you to life. I think it's well deserved. But as Mr. Wheeler pointed out, parties have reached an agreement, and I know they negotiated hard, and I am going to respect the agreement that they've reached, and I am going to impose it. But I hope you take these next 18 to 40 years to really think long and hard about what you did to Adren Thims. So with that being said, Mr. Hill, you're going to be sentenced to the Michigan Department of Corrections for a period of 18 to 40 years. With the following special conditions: you must pay crime victims assessment in the amount of $130 as ordered by the court. You must pay a $68 state cost as ordered by the court. And you must pay restitution in the amount of $3,926 to the Michigan Department of Health and Human Services. Last thing we will need from Mr. Hill is for him to acknowledge receipt of his initials, or his appellate rights with his initials and today's date.
And Your Honor, for purposes of the record, we'll acknowledge receipt of the appellate rights my client has initial dated before.
All right, thank you. Anything else before we conclude Mr. Hill's matter?
Nothing for the people, Judge. Nothing from defense, Judge. Thank you.
All right, thank you. We're very, very sorry to Mr. Tim's family for your loss.
Josh, again, your reaction to the judge's comments there.
Right. Well, when the judge specifically was referencing the boxing, he said, I don't want to hear anything about boxing. I saw the pictures. These are the worst pictures I've ever seen, and all the homicides and all the investigations I've had to look at. And this was belt loops, over 100 belt loops all across his body, his lower body, his groin, clearly taking issue with the defendant trying to minimize his involvement or trying to make an excuse for anything. And I think it kind of went back to what the prosecutor was saying also about he and the mother in tandem beating on this kid at the same time, so that this kid really had no chance of ever surviving what they were doing to him.
No chance. No chance. And, the judge, he honored the plea deal, sentenced Hill to 18 to 40 years in prison. We talked about whether it was controversial, lenient, what have you. Hill's attorney, Dennis Gary Whittle, told the Detroit News, "This is a tragic case where discipline went too far. Hill knows he cannot undo this horrible situation, but wants people to know that he never intended to cause Adren's death. His acceptance of responsibility through his plea of guilty is based on a reckless disregard for the potential consequences, but no specific intent to cause harm or death to Adren. He loves all of his children and has profound regret for what occurred to Adren." Real quick, what do you make of that statement, Josh?
Well, I think he was doing the best he could to trying to, make his client's statement sound a little bit better, and also explaining the difference between first-degree murder and second-degree murder. Obviously, first-degree murder, we talk about premeditation or someone's intent, but what makes it second-degree murder in Michigan is the reckless disregard. And so I think he was using that term to kind of explain how the plea agreement was reached and what he was admitting that his client was criminally responsible for. Obviously, he was in a very difficult position. It's, like we've talked about here today, it is very difficult to defend any of these actions when you have pictures like that, and it sounds like it was not in dispute about who took part in this. But all that being said, it looks like he reached a very favorable plea agreement for his client, so he should be, commended for that, I guess, from my side of it, my perspective of it.
So let's talk about the other defendant, because at last check, Kentoria Moss still facing charges of second-degree murder, lying to a peace officer in a violent crime investigation. She was scheduled for a competency evaluation back in June. Her next court hearing is scheduled for August 29th in the 36th District Court. Second-degree murder is interesting, right? Because we talk about what does it mean under Michigan law. I looked it up. It says all other kinds of murder shall be murder of the second degree, shall be punished by imprisonment in the state prison for life for any term of years, and the discretion of the court trying the same. Josh, why was she charged with second-degree murder? What does that say to you? And then I am curious, right? If he is pleading guilty, does that mean he's going to testify against her?
So I think she's charged with second-degree murder, which, again, makes me think that the culpability and whatever the evidence was points the finger much more strongly at him as being responsible as opposed to her. It sounds like she took part in it. So under the theory of criminal responsibility, she's just as guilty or just as liable. But just the fact that they're then also getting a competency evaluation kind of goes back to what we were talking before about, wondering like mentally if these two people were, low functioning or they had some kind of mental health issues as well, like which we just all assumed to be able to do something like this to a child and treat a child like this, and all the factors we talked about makes you wonder if there's something wrong with them. So it sounds like that's what's going on with her. I would be shocked that he would be testifying against her. I don't think that would be a good move for the prosecutor either, because that would probably allow allow the defense even more to try to point the finger at him and show what a monster he is, which may be the best defense that she has. So I would be very surprised if he was a witness that the prosecutor wanted to use.
This is a heartbreaking case, to say the least. Our prayers, our thoughts with Adren's family. There's really nothing else to say about it. We will see what happens with Kentoria Moss. But this is a closing of one piece of the chapter of this story. Josh Corman, thank you so much for taking the time. Appreciate it.
Thank you. Have a good day.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.